Today, we begin with a development that immigration attorneys, policy experts, and federal officials had feared, dismissed, and ultimately prepared for. A policy shift that unfolded not over months of congressional debate, but in a matter of weeks. Weeks that have already cost thousands of immigrants their legal status. Weeks that have separated families who thought they were protected. Weeks that have turned the American dream into an American nightmare for green card holders who believed they had done everything right. What the Department of Homeland Security did this month crossed a line that immigrant advocates had hoped would hold. And when that line broke, affected communities did not hesitate. They responded with confusion, with fear, and with desperate calls to immigration lawyers across the country. Because today, 4 critical visa rules have changed, and immigrants are losing their green cards. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. For several months now, there had been signals, not official press releases, not formal congressional announcements, just signals that the administration was preparing something unprecedented in immigration enforcement. The Department of Homeland Security has been aggressive, yes, but they have been predictable in their aggression. Their moves have followed a certain pattern, a rhythm, almost a formula that immigration attorneys could anticipate and prepare their clients for. But what set off alarm bells in immigration law offices across America this month was that the pattern went silent. Experts who monitor USCIS policy updates know the indicators. The sudden increase in request for evidence notices, the unusual delays in processing times, the quiet reassignment of adjudication officers, the sudden changes to internal guidance memos, all of that shifted dramatically. And whenever the immigration system goes quiet, it means something is about to get loud, very loud. What we are witnessing right now is not a minor policy adjustment. This is a fundamental restructuring of how the United States treats its legal permanent residents. And if you hold a green card, if someone you love holds a green card, or if you are in the process of applying for one, the next several minutes could be the most important information you receive all year. Early this month, immigration attorneys detected what they described as unprecedented denial patterns, including rejection reasons that had not been used in over 2 decades. These are the kinds of enforcement tactics that USCIS only deploys when they are signaling something very specific. A policy shift, a political priority, or a fundamental change in how they interpret existing law. Observers did not know which category this fell into, or whether it fell into all 3 at once. But what they did know was that the immigration system was changing its posture. And when a federal agency shifts posture without explanation, even by small measures, everyone pays attention. Let us break down exactly what has changed, because these 4 rule changes are not theoretical. They are happening right now, and they are affecting real people, real families, and real futures. The first major rule change involves continuous residency requirements. The warning issued by immigration policy analysts today was not normal. It was not routine. It was not symbolic. It was urgent. Source after source described the new enforcement approach as aggressive, unprecedented, and perhaps most importantly, retroactive in its application. Here is what has changed. Previously, green card holders could travel outside the United States for up to 1 year without automatically triggering abandonment concerns. The general guidance was that trips under 6 months were considered safe. Trips between 6 months and 1 year required explanation, and trips over 1 year required a re-entry permit. That framework has now been completely rewritten. Under the new enforcement guidelines, USCIS officers are now scrutinizing any international travel over 90 days. You heard that correctly. 90 days, not 6 months, not 1 year, 90 days. Within weeks of this policy taking effect, Customs and Border Protection officers began flagging green card holders at ports of entry who had been abroad for as little as 4 months. These were not people who had abandoned their lives in America. These were grandparents visiting sick relatives overseas. These were professionals completing temporary work assignments. These were people caring for aging parents in their home countries, and they returned to find that their green cards were being questioned. In some cases, officers placed them in removal proceedings on the spot. In other cases, their green cards were physically confiscated and they were given notices to appear before an immigration judge. This was not supposed to happen. This was not the law as anyone understood it. But it is happening right now across the country. Immigration attorneys, speaking with media under anonymity, describe the shift as a silent revocation, a way to reduce the immigrant population without changing any actual laws. But affected communities prove today that they will not accept this quietly. Their responses were not only immediate, they were organized so precisely that congressional offices began receiving thousands of calls within days. That response matters because it shows that immigrants are not passive victims in this process. It shows that communities are watching, documenting, and fighting back. The second major rule change involves the public charge determination. As reports continued coming in throughout the month, we learned more about the scale of this policy shift. Under previous guidance, green card holders who had legally used certain public benefits were generally protected from deportation. The understanding was that if you qualified for benefits, you could use them. That is no longer the case. The new public charge framework now considers any use of public benefits, even those you were legally entitled to receive, as potential grounds for green card revocation during the renewal process. This includes Medicaid, this includes SNAP benefits, this includes housing assistance, this includes programs that legal permanent residents have been paying taxes to support for years. Immigration judges reported a 300% increase in cases where public benefit usage was cited as a primary factor in removal proceedings. Green card holders who used emergency Medicaid during the pandemic are now receiving notices questioning their status. Families who received temporary food assistance during economic hardships are being told they may have jeopardized their permanent residency. This was not just a policy adjustment. This was not just a clarification. This was a fundamental betrayal of the social contract that legal immigrants believed they had with this country, and the consequences are devastating. One immigration attorney in Texas reported that 60% of her current caseload involves clients who are terrified to renew their green cards because they accessed public benefits at some point during their residency. They did nothing wrong. They followed every rule. They used programs they were legally entitled to use. And now they face the possibility of losing everything. The third major rule change targets employment verification in ways that nobody anticipated. Here is where the story becomes even more alarming. Policy analysts now believe that the administration's latest moves were designed to test the vulnerability of the immigrant workforce after years of labor shortages. They wanted to see whether employers would fight back, whether workers would accept the new terms, or whether the system would simply absorb the changes. But instead of quiet acceptance, the opposite happened. Worker advocacy groups did not stay silent. They organized responses that were so swift, so coordinated that even federal officials noticed. You do not get the Department of Labor's attention easily, but this month, immigrant workers did. Under the new employment verification rules, green card holders are now subject to continuous employment authorization verification. Previously, once you received your green card, your right to work was established permanently. Employers completed an I-9 form when you were hired, and that was the end of the verification process. That system has fundamentally changed. Now employers are being instructed to re-verify the employment eligibility of green card holders on an annual basis. This creates an enormous burden on both workers and employers. But more importantly, it creates constant opportunities for errors, delays, and wrongful terminations. If your green card renewal is delayed, which happens frequently, you may find yourself unable to prove employment authorization even though you are still a legal permanent resident. If USCIS makes a data entry error, which happens more often than anyone admits, your employer may receive a notice that your authorization cannot be verified. And in many cases, employers are simply terminating workers rather than navigating the complex correction process. Green card holders who have worked at the same company for 20 years are suddenly being told they need to reprove their right to work. The employment verification systems were not designed for this volume of re-verification requests. The backlogs are already building, and workers are paying the price. The fourth major rule change involves an expanded interpretation of criminal grounds for deportation. What makes this moment so critical and so dangerous is that this rule change happened at a time when immigration courts were already overwhelmed with backlogs. The new criminal deportability guidelines have expanded the list of offenses that can trigger removal proceedings for green card holders. Previously, only serious felonies and crimes of moral turpitude were considered grounds for deportation. That framework has now been dramatically expanded. Minor traffic violations, if accumulated, can now be characterized as evidence of poor moral character. Misdemeanor offenses that were previously considered too minor for immigration consequences are now being reviewed. Even decades-old convictions that were already adjudicated and resolved are being reopened. Immigration judges are now required to consider any criminal history, no matter how minor, no matter how old, as a negative factor in status determinations. This means a green card holder who received a DUI 20 years ago, completed all requirements, and has lived as a law-abiding resident ever since can now face removal proceedings. This means a permanent resident who had a minor shoplifting charge as a teenager can now be questioned during their citizenship application. The new guidelines do not distinguish between serious criminals and people who made minor mistakes decades ago. Everyone is now potentially at risk, and defense attorneys are overwhelmed. Immigration legal aid organizations reported that their phone lines have been overwhelmed since these changes took effect. Pro bono attorneys are being asked to take on cases at 5 times their normal rate. And there simply are not enough immigration lawyers to help everyone who needs representation. Remember, green card holders thought they had achieved security. They thought they had earned their place in this country. They thought the immigration system, however flawed, would recognize their contributions and protect their status. But today, the exact opposite is happening. Security is being replaced with uncertainty. Earned status is being questioned and revoked, and the immigration system is treating legal residents as suspects rather than contributors. This is not what America promised. This is not what the immigration system was designed to do, and yet here we are. What makes this moment so unprecedented and so frightening is that these rule changes happened at a time when anti-immigrant political rhetoric is at an all-time high. Hardline factions want maximum deportations. Business interests want continued access to immigrant labor. Humanitarian advocates want protection for vulnerable populations, and legal scholars want adherence to constitutional principles. The administration is balancing these demands while simultaneously restructuring the entire immigration enforcement apparatus. And when policymakers in that position make sudden moves, they are not doing it from a place of careful deliberation. They are doing it from pressure. They are doing it from political calculation. They are doing it from a desire to satisfy certain constituencies regardless of the human cost. The Department of Homeland Security's statement, now circulating widely in immigration communities, was designed to signal that the government is not willing to maintain the status quo on immigration enforcement. Officials said plainly that the previous approach to green card enforcement was inconsistent with current policy priorities. That is bureaucratic language for we are changing the rules, and you need to adapt or suffer the consequences. You do not usually hear that tone from federal agencies unless something serious is at stake. And for millions of green card holders, everything is at stake. Their homes, their jobs, their families, their futures, everything they have built in this country is now subject to rules that did not exist when they made their decisions to immigrate. Meanwhile, immigrant advocacy leaders addressed affected communities in urgent, desperate communications this week. They said, do not travel internationally unless absolutely necessary. They said, document every day of your physical presence in the United States. They said, consult with an immigration attorney before renewing your green card. And they said, prepare for the worst while hoping for the best. These are not rhetorical flourishes. These are survival instructions from organizations that understand just how high the stakes have become. Here is what makes the situation even more concerning. The 4 rule changes we discussed were not isolated policy adjustments. Along with these enforcement changes, USCIS also increased filing fees by an average of 35%. Immigration courts reduced the availability of continuances, making it harder for respondents to prepare their cases, and ICE expanded its presence at routine USCIS appointments, creating fear among immigrants who were simply trying to comply with administrative requirements. All of this happened within the same policy cycle. When the immigration enforcement apparatus moves multiple pieces at once, it means something larger is underway. This is not random. This is not coincidental. This is coordinated, and it is designed to achieve specific outcomes. Immigration policy analysts are now considering several possibilities. One is that the administration is preparing for a large-scale reduction in the legal permanent resident population. Another is that these changes are attempting to discourage future immigration by making current immigrants' lives more difficult. A third possibility, the one worrying advocates the most, is that these rule changes are attempting to create a permanent underclass of immigrants who are too afraid to access benefits, too afraid to travel, and too afraid to assert their rights. But today, immigrant communities took that fear off the table. They did not stay silent. They did not accept these changes passively. They did not give up hope. They organized. They documented. They fought back. What we are watching now is a test of resilience. The administration wants to see whether immigrants will quietly accept diminished rights. Advocacy organizations want to show that communities will resist unjust policies. Courts want to prevent constitutional violations from becoming normalized. And Congress wants to prevent immigration from becoming an even more divisive political issue. The outcomes of these competing interests will determine the future of millions of people. Today, we have heard from immigration attorneys who are now monitoring case outcomes daily. They say denial rates have increased by 40% in the last quarter. They say requests for evidence notices are being issued at unprecedented rates. And they say the administration's decision to implement these changes simultaneously is likely part of a broader strategy intended to overwhelm the immigrant community's capacity to respond. But immigrants are not surrendering. In fact, immigrant communities are mobilizing in ways we have not seen in years. Their response today, organized, documented, and strategic, sent a message to the administration that these policies will be challenged, and it sent a message to Congress that legislative action may be necessary to protect legal permanent residents from administrative overreach. As the coming months unfold, we expect more details to emerge about what exactly the administration hoped to achieve with these rule changes. But what we do know is that early awareness was critical. It allowed affected individuals to consult with attorneys before making decisions that could jeopardize their status. It allowed advocacy organizations to document patterns of enforcement, and it allowed communities to prepare support systems for those who would be most affected. What happens next will depend on what the administration does in the next few months. If they moderate their approach, this moment will be remembered as a warning that was ultimately heeded. If they escalate enforcement, immigrant communities have already shown they are prepared. They have shown they are organized. They have shown they are ready to respond. And today, for the first time in decades, the immigration system appears to be at a crossroads. USCIS field offices are quiet, too quiet. And when the immigration bureaucracy is quiet, it means they are processing. It means they are implementing. It means they are choosing their next targets carefully, because today, millions of green card holders learned something they should have known all along. Permanent residency is not truly permanent. Legal status requires constant vigilance, and the rules can change without warning. This story is far from over. But today, one thing is clear. Green card holders must take immediate action to protect themselves. Documentation of physical presence is now essential. And consultation with an immigration attorney is no longer optional. It is survival. If you hold a green card or know someone who does, share this information immediately. Subscribe to this channel for continuous updates on these developing changes. And remember, in immigration, what you do not know can destroy everything you have built. We will be here watching every detail as the next phase unfolds. Stay informed, stay prepared, and stay vigilant. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.